So you recently got your stunt driving charge in Ontario and the interaction with the officer is fresh on your mind. You are investigating the documents, you got the summons, the impound documents, the notice of the 30-day suspension, and you were trying to find mistakes. And it's natural. It's a natural reaction to try to find anything that can help or get the case dismissed. So let's investigate this. The interaction with the officer when you were charged with stunt driving charge. Now, there are a few factors that clients are concerned about when they're charged with stunts. Sometimes the interaction with the officer is calm and pleasant. Other times the tension runs high. Sometimes the officer places you under arrest while issuing the summons, and sometimes you remain simply near your car. Sometimes the officer assists with getting you a ride to your destination after your car is towed. Other times you are left to deal with this on your own. There is no set formula. It is important to understand that a stunt driving charge falls mainly to the radar or the laser and the calibration. And this is the real basis of the evidence that the court relies on. So anything that transpires with the officer, obviously unless it's illegal, would not have much of an impact on your case unless it actually changes the radar. So these interactions with the officer rarely have any impact on your case once you arrive in court. The officer did not show me proof of my speed. It's a common question. Well, this is not an error. The officer does not have to show you the radar at the road. They do, however, have to submit all of this data, the radar, the calibration, where they caught you, how they caught you, etc., to the court within a reasonable period of time in the form of evidence. So once you get this evidence, then you can examine it for errors. However, not receiving this information when you were charged with stunt at the road, it's not an error. Now, the officer made an error on my impound documents or notice of suspension. Well, the impound and 30-day suspension of your license for stunt driving, it's a pre-court penalty. So small errors here, they don't generally affect your case. Remember that unless these mistakes actually affect the radar or the laser, they will not have a major impact on the case itself. Stunt driving in Ontario is something called a strict liability charge. So what the heck does that mean? Strict liability, in plain words, it means that the court will generally rely on the radar or laser to obtain a determination of guilt. A provincial prosecutor and a justice of peace, they don't need much more than that, than the calibrated or paced speed of your car to convict you of stunt. So the only important error can be found in the radar. Well, people ask, what about my dash cam? It doesn't match up with the radar. Can I use this? Well, a personal dash cam is generally not recognized as a calibrated time determination of stunt driving. The court recognizes the police officer's radar or laser used by the officer, and it sets a standard of evidence by which the court can most often rely on. So trying to tell a prosecutor about your dash cam reading generally just frustrates a prosecutor or officer and is not accepted as evidence.